This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Hello everyone and welcome to Internet Law Review. I hope you're having a great day as always. So we are here on a React video, or React audio to be more precise, because it's federal court so we don't have video, but we do have audio. We have an MP3 and we're going to listen to this, and I'm going to read what Tactical Bra told me about this before I told her to stop spoiling details to me, because I wanted to share my reaction with you. So I'm just going to read what she told me about this case, because it sounded like something that we'd be interested in. So here's how she describes it. Basically, the police broke into a guy's house because the guy was selling weed or something, and the police didn't identify themselves, and they weren't dressed as police. It was the middle of the night. The guy had a gun by his side, but he didn't aim it at the police. The police fired 29 times, the guy was hit 9 times, and the guy sued the police for excessive force, and the police were denied qualified immunity. And they, the government, is appealing the denial of the qualified immunity, and the judges are ripping the attorney apart. And that's when I said, stop spoiling it to me. I don't want to hear anymore. So this was an appeal heard yesterday in the Fourth Circuit Court of Appeals, which is based in Richmond. So the only bit of graphic you are going to get to see is an image, which is of the Fourth Circuit Court of Appeals, because why not? And this case originated out of Myrtle Beach, South Carolina, which is my home state. As you can tell from my banner, if you didn't know, Clemson University is based in South Carolina. And so you get to hear a nice Southern accent. I mostly have lost mine. We get to hear from a nice Southern accent. Reminds me a little bit more of home. So we're going to get started and listen to this, and we'll react to it in real time and watch the government get crushed. We're not doing Philly cheesesteak, man. That's Pennsylvania. This is South Carolina. I can't help you with the Philly cheesesteak. I can help you with some grits and some shrimp boil. So let's get started on this, and audio only, as I said, because federal court, but we'll do what we can.
Our final case is Betton versus Blue. Mr. Battle?
Yes, sir, Your Honor.
Good to have you here, sir.
Yes, sir. Thank you. If it pleases the court. My name is James Battle. I am here representing Appellant David Ballou.
The government.
The purpose of this appeal is to request this court to reverse the lower court's decision to deny qualified immunity from my client as to the plaintiff's excessive force claim. So that is the legal posture or the purpose of the appeal. I submit that the issue before this court is, was it reasonable for David Ballou to feel threatened by Julian Betton when he went into his home and Julian Betton drew a firearm on him in response? That is the issue and the action and the conduct that triggered this use of force by my client.
All right, so what we've got going on here is we've got one of the officers appeal the decision to be denied qualified immunity. So that's the Benton in this argument. And Blue is the guy who was shot at. And Benton versus Blue. And yes, the attorney's name is Mr. Battle. So, hey, let's carry on.
Well, now, Mr. Betton's testimony was not that he drew a firearm on the officer. He said, I didn't get a chance to pull it up or anything. He took it out, took it out of his waistband. He says, I guess the gun was by my hip. I didn't get a chance to pull it up or anything. And the next thing I remembered, I was in the hospital.
Yes, ma'am.
So that's different from what you just told us, isn't it?
He has it in his waistband. Mm-hmm. He steps around the corner into the den where the officers are and draws the gun in response.
Well, he said he had it down by his hip.
That's correct.
Mm-hmm.
When I say draw,
I mean, we have a dispute of facts, is my point. And it seems to me that you're trying to characterize it as undisputed. And to me, this case appears to be riddled with factual disputes.
When I say draw, I mean taking it from the back of my waistband to presenting it, to having it by his hip. I don't use facts represented by my client. I use the testimony of the plaintiff.
I thought you had to accept the facts as related by the district court.
Your Honor, it's my understanding this is a de novo review. And so this is to review...
But the facts.
The facts.
It's de novo review, but the facts are accepted as related by the district court. Mm-hmm. Right?
I I don't take that to be the posture of how we
can't be a
treat this
dispute of
appeal.
fact.
That is the posture. I can guarantee you it is the posture. That's 100% correct. We're on a motion to undo the qualified immunity. So if there was a finding of fact by the lower court, the de novo issue is as to the qualified immunity, the legal issue. The facts are the facts. So if the lower court said X happened, then X happened. And so that's legal posture. I know that, and I'm sure he does too. Let's continue.
Fact here. You all have to be on the same page as to the facts.
Yes, sir. Absolutely. No disagreement.
Okay.
We adopt those facts. I
Good.
don't use my client's facts. I
Good.
use Julian Betton's testimony from
But
his
then
deposition.
you have to accept them the way Judge Keenan related them to you.
He said I had the gun, I had it down,
Right, at his hip.
which sounds an awful lot like Cooper, doesn't it?
No, ma'am, it does not. So in Cooper, the man walks out onto the porch. He's in mere possession of the firearm. He says, who's there? He thinks, there's someone crawling or walking around his house. And then the officers approach him from the porch. The Cooper decision is that mere possession of the firearm is not enough to trigger a use of lethal force.
Another important thing that comes in Cooper right after that is the assumption that a man who greets law enforcement with a firearm is likely to pose a deadly threat rests on the fact that the man reasonably knows that the police are in fact the police.
And that
here,
goes to...
they lied or made false representations. Every single one of them said they knocked and identified themselves as the police.
Right.
And it's no longer contested that none of that's true. So
Oh, did the police lie? Did every single police officer say, yes, we knocked and identified ourselves, and the district court said, no, that didn't happen? What do you think, guys? Is it possible that every single police officer testified falsely? Do you think that might have happened? Apparently, the Court of Appeals says it does because the district court said it did. So that's super positive. Always off to a positive start. And for the district court to find that the police were lying, it must have been one hell of a lie because, as you might imagine, courts are somewhat inclined to believe the police. So it must have been a pretty obvious lie. So we're off to a really shining start. Let's continue.
all of these ununiformed officers with no indication they're police, with no word spoken that they are the police, break into an apartment with a battering ram
Without knocking.
without knocking.
Without knocking, good.
And a guy has a gun as the intruders come in, and he was afraid, but pulled the gun and had it at his side.
Absolutely, Your Honor. And that is a great opening statement for the plaintiff's argument on the unlawful
Is there
entry.
anything untrue about that?
I'm not going to admit, facts
Well,
or...
you have to take them. I thought that our case law is that we must accept the facts as the district court articulated them.
That is the case law in every single circuit in the country. The lower court said these are the facts. He says, I'm not going to admit it. You have to. Unless you have overwhelming evidence, unless you're going to argue the district court made clear manifest error, which that's one hell of a standard, you have to accept those facts. Those are now the facts. So it's like, I'm not going to admit those facts. You kind of have to. That's your legal posture now. So things are not off to a great start.
As to the use of force, the unlawful entry is not on appeal before this court.
That's a question that is bothering me.
Yes, sir.
You seem to want to restrict the unlawful force analysis to the moment they pull the trigger. How far back does it go in your judgment?
To when that engagement begins, when
When
they
did that
encounter...
begin?
When Julian Betton drew his firearm.
So, nothing that happened before that, them breaking into his house unannounced, not being identified as police, none of that counted as it did in Cooper, but it didn't count here.
Yes, sir. That's
No,
accurate.
well, it has to be part of the mix. I mean, it seems to me that what you're doing is you're saying we don't rely on the fact of an unlawful entry. That's correct. I agree with you because the Fourth Circuit has looked at the time that the use of force was employed as opposed to other circuits. But that doesn't mean that the facts are irrelevant, that this man who saw these armed invaders, and he was nothing from the record but a nickel and dime drug dealer, a few grams of marijuana, you wouldn't think that all of these armed commandos were coming into your house. You had no idea they were police. You've got to be, that has to be part of the issue here. Not whether there was a legal issue of unlawful entry, but his reaction when confronted in a small space with this commando unit.
Yeah, if we're looking to the always ever popular reasonable man test, which is pretty much the standard, and we're going to look to things from his frame of view, which seems as reasonable as anything else, and we're looking to the moment of the use of force as the moment, we still have to go into what was going through his mind at that moment. And things that might be going through his mind at that moment might include, my door was just busted down with a battering ram, and here are a bunch of people not in uniform with guns. So, that might be factually relevant to the actual question we're trying to answer, to the moment. So yeah, that's, kind of important, I would think. Good question. Good question, Judge. Let's see what your answer is. Hopefully your answer will be just as enlightening.
Right. Okay. Julian Betton's mindset, which I believe is where the court is focusing, is not part of the analysis in a
wrong answer.
Use of force cause of action. It is from the perspective of the officer. So let's take the court's point.
No matter what the officer's conduct is, no matter what the officer's circumstances were or how they were created.
For the use of force, yes, sir.
Okay,
the unlawful entry.
No matter what.
Yes, sir. And
so this is the government's position. Just in case, first of all, thank you, Joe Tyson, for the $10. Very much appreciated, as always. This is the government's position. It doesn't matter that we illegally entered his house. It doesn't matter that we testified. Every single officer testified that we knocked, but we didn't. So the fact we lied under oath, which, when you lie under oath, that has a name for it. I can't quite remember what it's called. I think it starts with a P and ends with perjury, something like that. It's just, I can't quite put my finger on it. But, I was told that it's kind of serious when that happens. So the fact that crime, which name escapes me, occurred, and the fact that they illegally entered the house, and the fact that they weren't wearing cop uniforms, none of that matters, because all we're looking to is the moment they pulled the trigger. So let's just ignore all those inconvenient details and just focus on the actual use of force. Great.
I point the court to L.A. County versus Mendez. The Ninth Circuit raised arguments very similar to what this court is saying, where you have this provocation, the use of force was provoked by the means of entry.
I'm sorry to keep interrupting you.
Yes, sir. That's okay.
I can just envision armed men breaking down my front door and starting up the stairs in the dark, and let's just suppose I have a firearm, and nobody shouts police. And when they appear, nobody's wearing a police uniform or identifying themselves. I think I might get the gun out.
Yeah. This is a relevant issue. And I'd like to note this case started in South Carolina and is being heard in Virginia, both of which are relatively gun-friendly states. So the probability that, this judge actually has a firearm is not exactly zero. So yeah, if I were in this position, I might be doing the same thing. Also, Blackleaf might be doing the same thing. So, it seems like a reasonable course of action. So what is your answer to, this seems pretty reasonable on the part of the homeowner? What's the government's answer to this? This will be good.
Yes, sir.
Is that unreasonable? And if it's not unreasonable, then why is it reasonable for the police officers to shoot 22 times or whatever it was?
29.
Yeah, how is this case a bad guess in a gray area under our law? I mean, this is just it doesn't even seem to be a guess. I mean, they just came in to unload on this guy. I mean, cheating 20 some times.
Does it not matter? I'm sorry to interrupt, but
Okay.
does it not matter that it was just a marijuana charge and they decided to go there where the door was unlocked and knock it down with a battering ram and run in with no identification? Does that not matter at all?
Oh my God. There's only 3 judges on this panel, and all 3 of them are interrupting each other, basically on how incredulous they are. They can't stop interrupting each other just because they can't believe the words coming out of this guy's mouth. This is painful. Not only over weed, over what they're describing as nickel and dime amounts of weed, grams of weed, so personal possession amounts of weed. In Myrtle Beach, South Carolina, which for those of you who are not familiar with Myrtle Beach, South Carolina, it's a pretty kind of touristy town. It's a little touristy trappy, but it's also very developed touristy trappy. It's also apparently the mini golf place to be. I think they actually have the national mini golf tournament there, and apparently they've got more mini golf per capita than anywhere else. So just FYI, it's an interesting place. So the idea that there might be weed there, think of your oceanfront USA kind of town. That's Myrtle Beach. And so there might be pot there, just saying.
The tactics used to, the SWAT-like tactics, that cause of action was dismissed by the lower court. If that's what the court is referring to.
That wasn't what I was doing, but I made my point. Go ahead.
Okay. So where I think the court is drawing concern is that Mr. Betton is in his home, and there's a common
That's
belief.
pretty important. He's in his home.
Yes, sir.
Yeah, he's in his home. And as I pointed out in a prior video, many, many times, the home is special.
People break down the door.
Yes, sir.
They don't say who they are. They're
Yes,
not
sir.
dressed as police officers. And they come in.
Yes, sir.
What did he do was unreasonable?
It's not that his action was unreasonable, it's that my officer's actions were reasonable.
Okay, so if we construe the evidence in the light most favorable to Benton,
Right.
isn't really the question we have in front of us whether it was clearly established that a group of police officers armed with weapons and battering rams can enter a home without identifying themselves as police and shoot a man who is holding a gun at his hip? Isn't that what this case is about?
That is the unlawful entry cause of action.
No. Can shoot a person after.
No, says the judge. You just know at that point it is not going well for you. It's just, I feel for this guy because he has horrible facts and he has to argue horrible facts. But man, oh Lord, I'd hate to be this guy. I feel for him a little bit in my soul right now. I'm telling you. And the judge went, no. Oh my God. Press F to pay respects.
After having done this, in other words, entered his home without identifying themselves, forget the unlawful entry cause of action, but can do that. How is this a gray area for the police? To shoot somebody 20-some times, and even if we were to give you the first shot, how do they have a right to unload 20-some shots at this man? To me, I'm sure you've looked at that video.
Yes, ma'am.
Of the swarm of officers going into the.
Oh, there's video. Oh, we may have to find the video, guys. We may have to find the video and play that. Oh, okay. Let's carry on with the oral argument, though.
Place. If you pardon my saying so, your argument strains credulity.
Strains credulity. Oh, get wrecked.
It's just so shocking what occurred in this case for a 2-bit marijuana dealer.
If they didn't think it was important to identify themselves, why'd they lie about it?
Why did they lie about him firing a shot when the evidence later proved that he didn't?
Oh, so the police told another slight mischaracterization, guys, before they testified that they knocked, and that didn't happen. And then they testified the guy fired a shot, and that didn't happen. Again, there's a word for that. Starts with P, ends with urgery. I think it's kind of important. And apparently there's multiple police officers. I think that might be relevant in some way.
I'll draw a distinction between a lie and a falsehood. I don't know that.
Did you hear that? Did you hear that, what she just said? Did you hear it in the background? Did you hear what she said? I'm going to wind it back just a little bit because I think I talked over it. I want to make sure we hear that all together. Listen carefully.
Shot when the evidence later proved that he didn't.
I'll draw a distinction between a lie and a falsehood. I don't know that the officers.
Did you hear that? Did you hear that where she said, "Oh, come on"? Did you hear that? She said, "Oh, come on." Thank you again, Joe Tyson, for the $10. Oh, okay. Oh, come on. That's like, I'm going to draw a distinction between a lie and a falsehood. And under her breath, she says, "Oh, come on." In fact, I want to hear it one more time. I got to hear it one more time, guys.
Proved that he didn't.
I'll draw a distinction between a lie and a falsehood. I don't know that the officers, what they're conscious of and what they say.
You don't admit that they lied?
No, sir.
You don't admit that they lied?
No, sir.
Okay.
I draw a distinction between saying something that it ends up being false and making a conscious decision to lie.
Well, I'm going to sway in on this just for the heck of it. Say in this case they were lying. That's my judgment.
Out. Oh my God. You just hear that? What the appellate court just said? That guy just said, "Well, I'm going to weigh in just for the hell of it. This is a lie in my judgment." Holy shit, dude. Holy shit. I got to hear it again. I got to hear it again.
I'm going to sway in on this just for the heck of it. Say in this case they were lying. That's my judgment.
Okay.
Go ahead.
Okay. I will.
How many falsehoods did SLED identify?
How many falsehoods did SLED identify? For those who don't know, and I wouldn't expect you to, SLED is an acronym. It stands for the South Carolina Law Enforcement Division. It's state-level police. And growing up in South Carolina, I can tell you from personal experience that SLED likes to think that they're the FBI and tends to act more important than they are. So the fact that this was SLED that did this in absolutely no way surprises me, because they like to pretend that they're much bigger than they are. So the fact that this is SLED who did this is not surprising. They tend to be they tend to think that they're a little bit cowboyish, let's say. Yeah, so that's who SLED is. South Carolina Enforcement Division. They're special, not in a good way.
The SLED report was like a forensic, physical evidence report of what happened. We did an internal affairs investigation.
Did they say they knocked?
I don't recall that they analyzed, on the entry.
Did they say they announced?
I don't recall that being in the SLED report.
Ooh, I don't recall that being in the SLED report. I don't recall this. Oh my God, counselor. Oh, I'm so sorry for you. I know you're in this horrible position, but game over, man. Game over.
I guess it's that.
Did they say he fired the first shot?
Which one?
Did the SLED report say that the officer said that Mr. Benton fired the first shot?
No, the SLED report said he did not fire his gun.
All right.
Right, but the police claimed that he did.
Yes, ma'am.
So the falsehood was that he was asserted to have fired the first shot.
Yes,
and he
sir.
had not fired the first shot.
Yes, sir.
Okay.
Officer Waddell reported in his statement to SLED that all agents announced police presence. JA 2801.
Yes, sir.
Okay.
In fact, not.
JA stands for Joint Appendix, so it's a joint agreement. So that's a page citation there.
That's an issue of fact.
Did you look at the video and see anybody moving their lips? I looked hard to see them move their lips. I didn't see a single set in action.
Right. It's standing before the court today, it seems that we haven't gotten past the entry, that the unlawful entry cause of action is the focus in this argument. And
the court hates your client. The court wants your client to die. So they're focusing on everything because they hate your client and they want them to die. And now they're murdering you via proxy. So that's what's happening, just in case you were confused.
I want to extract the use of force.
The question is, did the...
No, it isn't. No, it isn't. Oh, the judge, again, just slapping you down. It seems like you're focusing on this. No, it isn't. No, it isn't. Oh, my God. I feel that in my soul.
Police have a right to unload their weapons into somebody in his private home when he is standing there with a gun at his hip. Not pointed at the officers, not firing at the officers. Do they have a right to unload their weaponry into this person?
He's drawn his firearm in reaction to seeing the officers.
He's holding it down at his hip. That's the record. It is.
Okay. Am I dismissed?
No.
Oh, okay. I thought she's...
Am I dismissed? No. They're not done with you yet, my friend. They're not done.
It is.
Okay. Am I dismissed?
No.
Oh, okay. I thought she said
you got
next.
some time. You're on the yellow light, but you
Okay.
still got whatever time you can see it better than I can.
Well, if the court views his testimony as holding
You have
it,
to accept the facts the way they were articulated by the district court.
Right.
To argue this kind of an appeal.
right?
It's a collateral order appeal,
Yes, sir.
saying the court missed it on the excessive force claim.
Yes,
The
sir.
court was wrong, taking the facts
That's right.
as the court perceived them. The court was wrong. So, but you don't want to accept those facts. It doesn't seem to me. You want to argue a different set of facts. You want to change.
You know, for whatever it's worth, for guys criticizing this guy on passing the bar or not, you know, I honestly don't know that I could do any better in his position because the facts are just horrible. The facts are horrible. The police officers lied multiple times or told falsehoods or whatever, and he's desperately trying to crawl out of a very deep hole someone created for him. So I honestly don't know I could do any better if I were the lawyer in this position. So I'm not saying, oh, I could do better. What I'd want to do is confess judgment and basically, yeah, we screwed up. But if I had to do this, I don't know that I could do any better. And all I could do there is go there and take my licks. So, you know, I'm sure he passed the bar. I'm sure he's a good lawyer. He's not doing any worse than I could do. Facts are just horrendous. Let's carry on.
Change the facts.
I will directly.
And you can't do that here.
Right.
In this kind of appeal, you just can't do it.
I will directly quote Mr. Betton's testimony. It's that, okay, so you have the Hensley case, which is like what we're describing here. It occurred after this raid, but where the gun is held down. The drawing of the firearm in reaction to the police is a threatening gesture. He is 8 feet away from the officers at the time that he draws the firearm.
Holding it down at his side, according to JA 1999, 2376 to 77.
That's again a page citation.
His testimony is he got it to his hip. There's no indication that there was a pause where he's investigating.
I had it down. The gun was by my hip. I didn't get a chance to pull it up or anything. That's a quote from the record.
Right.
He was hit 9 times, and 29 shots were fired.
Yes, sir.
The next thing he remembered, he was in the hospital.
Yes, sir.
Somebody comes charging into my house in the middle of the night with ski masks on and weaponry and don't identify themselves as police, which, by the way, an intelligent clerk would do. And they come into my bedroom, and I decide that it's okay to defend myself because they shouldn't be in there.
Yes, sir.
And, Heller makes a special deal about defending my house. And I reach for my gun in my bedside table or in my secret compartment or wherever I might have such a thing.
Mm-hmm.
Fire away.
I will answer that question in the reverse. Is the officer supposed to be shot because the entry was improper?
Okay, look.
I would say yes. And incidentally, there are courts who have said yes to this question before, where they would say yes, the officer should be shot. So yes would be a viable answer to this question, and I would say yes. So let's see what the court says.
Sorry, excuse me. I'm assuming that's not an answer.
No, it's not.
Okay. Where in the record does it show that Officer Ballou saw Betton draw a gun? Where in the record? Can you point us to that?
The fact that she's asking this question leads me to believe it's not there, but let's see what he comes up with.
I believed it was in his deposition.
Okay, can you point us to the place, if you'll do that on rebuttal?
Absolutely. I see my time is up. Thank you.
Thank you very much, sir.
Oh, it's over. Oh, thank God. In appellate courts in the Fourth Circuit and the Federal Circuit, you only get 15 minutes per side. In the U.S. Supreme Court, you get 30 minutes per side. In this case, it was 15 minutes too much, man. I was feeling that all the way. That was the most painful 15 minutes of my life. Let's see what the guy who shot's attorney has to say. Does he want to say anything, or does he just want to say, I'm done? Because I'd be tempted to say I'm done. But let's see what he has to say on the issue.
Mr. Gosh, nice to see you, sir.
Good morning. May it please the court. I'm Narendra Ghosh, and along with Burton Craig, Paul Smith, and Johnny McCoy, I represent the plaintiff, Julian Betton. On April 16th, 2015, 10 DEU agents converged on Mr. Betton's home. 5 of those agents ran up to his front door. None of them knocked. None of them announced themselves as officers. Instead, defendant David Ballou held open the screen door while another agent ran up with a battering ram and smashed down the front door. Mr. Ballou and 2 other agents then rushed into Mr. Betton's home with their semi-automatic rifles raised. Mr. Betton was walking out of his bathroom when he heard his front door being smashed down. He did not know that the men who entered were law enforcement. They did not identify themselves upon entry. They gave no warnings or commands. They were not wearing uniforms. Instead, they wore a mix of face masks, backwards baseball caps, short sleeve shirts, long sleeve shirts, jeans, khakis. Startled by the break-in,
Uncle Blackleaf would shoot these people in this scenario. So, yeah.
Mr. Betton reached for a gun in his back waistband and pulled it out and held it down by his side. He did not point it at anyone. He did not raise it. He did not fire the gun. Rather than saying anything like police or drop your weapon, Agent Ballou and the 2 others fired 29 shots at Betton, hitting him 9 times and paralyzing him for life. Now, to address
what kind of semi-automatic rifle was that?
Excuse me, Your Honor?
What type of semi-automatic rifle was?
I do not recollect the precise type. It did require them to pull the trigger each time that they fired.
Okay.
To address one of the questions, this court's review is based on the district court's articulation of the facts, because it's coming up on an interlocutory appeal on qualified immunity. And so Your Honor is correct, and that's how this court has to look at it. And as Your Honors emphasized, the way that the magistrate judge described it is that at JA 2815, Mr. Betton, quote, reached for his gun and held it by his right side, at which point the officers opened fire. And obviously this is based...
Did you have an argument in the district court on this? An oral argument, or was it decided on the paper?
There was no oral argument for either the magistrate or the district court judge.
Okay.
Could I just bother you with something? Yeah. Is there really a distinction, and I realize there is in the case law right now, between somebody suddenly pulling out a gun to point it at the floor and somebody suddenly pointing out a gun and raising it some, in terms of the police officer's fear for their life?
I think there is a distinction if Mr. Betton had pulled it out and raised it toward the officers. Now, I will emphasize that.
The officer has a right to defend himself.
Yes, Your Honor, although it's worth emphasizing that, and the defendants rely on a number of Fourth Circuit cases, but in each of those cases, the plaintiff had, before he was shot, he had disobeyed an officer's command and then reached for an apparent weapon before being shot. And of course, disobeying the command to a known officer is crucial because someone, as this court said in Cooper, someone who greets law enforcement with a weapon, officers can presume that they're likely to be a threat. Where, however, as in Cooper, as in this case, where the home resident has no way of knowing that he is confronting law enforcement, his, quote, perfectly reasonable rationale for bearing a gun should have been apparent to the officers.
Were any commands given here?
No, Your Honor, on the record, in the light most favorable to us.
On this record, were there any commands given?
No, Mr. Betton testified that there were no commands, and it wasn't just him. His neighbor, Santos Garcia, who is shown on the video as the individual who sort of is outside and kneels down, he submitted a statement that the officers never identified themselves at any point. So taking the record like that there is no evidence of commands or warnings or anything before they started shooting.
You'd agree with me that if a person believes he or she is meeting an intruder, an unlawful intruder into their home, that the police cannot reasonably assume that because that person holds a weapon, he or she poses a threat?
Yeah, I agree with that, and I think that is squarely the holding of Cooper, and that is consistent with obviously the number of cases about the Second Amendment and the importance of the right to bear arms, particularly in defense of one's home.
So you're saying that Cooper is enough then to establish or to satisfy the clearly established prong?
Yes, Your Honor. Cooper provides...
Okay, what are the key facts of similarity then?
Sure.
Between Cooper and this case that remove the clearly established prong from...
All right, so just to keep up where we are legally on this issue. So under qualified immunity doctrine, the police are immune from their actions unless the right they were violating was clearly established at the time of the offense. So when they're talking about clearly established, that's what they're talking about. So they're asking about this prior case, Cooper. And they're asking, does Cooper establish this either by its own facts on its own terms, or is it sufficiently close? Is it sufficiently parallel that it's, that there's a close enough nexus to read it? So they're looking for a rationale here at this point to find that this was clearly established at the time that this would be in excess of what they were allowed to do, just in case you're wondering where the legal posture is. So let's listen on.
Dispute here.
Yeah. As in Cooper, the agents here were investigating a nonviolent offense. As in Cooper, the agents had intruded on Betton's private property without identifying themselves as officers.
Cooper lived in a mobile home down in North Carolina somewhere.
I think that's correct, Your Honor. But they had intruded upon at least the curtilage of the home.
Right.
Yes.
Curtilage?
And certainly they were on his private property. As in Cooper, Mr. Betton had no way of knowing the intruders were law enforcement officers. As in Cooper, Mr. Betton was holding a gun by his side when he was shot. As in Cooper, Mr. Betton did not raise the gun or point it at anyone. As in Cooper, the officers did not give any commands or issue any warnings. And as in Cooper, Mr. Betton did not make any threats or disobey any commands. And so given...
Sounds like, I think you were prepared for that question.
That's right.
You hear what the judge says? I think you were prepared for that question. And he should be, because that is like a major question in this frame. He's like, what is the clearly established case law? So he's like, well, here's this case, Cooper. And they asked, well, why is it parallel? And he said, well, here's all these facts that are the same in this case and the same in this case, and therefore it's clearly established. And he says, well, you're clearly prepared. This is like what a competent attorney does. You know that that's the question they're going to ask. Of course, it's the question they're going to ask. It is like the central question. And so you have to come prepared with, well, here's the prior established case law that makes this clear. And he says, oh, you seem like prepared. Yep, good lawyering. It helps when your client is not a dirtbag. Just incidentally.
So Cooper is on all fours and provides the requisite level of specificity to provide clearly established law for qualified immunity analysis. And the Supreme Court has issued decisions about qualified immunity. It has said there does not need to be a case directly on point. Well, right. There does not need to be, but in this case there is. And Cooper is directly on point. And were there any doubt about the constitutionality of these sorts of actions, they were eliminated in 2013 when Cooper was decided.
Good answer.
There were several questions about the relevance of what happened in the moments before Mr. Betton was shot. And those facts are clearly relevant because they show that Mr. Betton had no way of knowing that these were officers. And that's why the facts about how the officers approached and failed to announce are plainly relevant in Cooper. What the officers did and did not say were relevant in Hensley. It's black letter law that in deciding whether a use of force is objectively reasonable, one looks at the totality of the circumstances. There is no case law that you just cut off everything that occurred, before more than 1 second before the shots are fired. No authority for that whatsoever. The Mendez case, the Supreme Court case that counsel referred to, in no way supports that proposition. The Supreme Court there just said the fact that there was unconstitutional entry does not in and of itself make a reasonable use of force unreasonable. That is certainly not what we are arguing here. Although there was an unlawful entry and that issue is not here on appeal, we're not saying that unlawful entry is what makes this unreasonable. This is unreasonable on the facts just as they are. But how that entry occurred is relevant. The analysis in this case would be different if the DEU agents had knocked and announced, or if they had identified themselves after entering, or if they had issued any commands, or if they had issued any warnings, or if they were wearing proper uniforms. But they didn't do any of those things. Instead,
you're saying all those things are relevant.
All those things are relevant because when officers have completely failed to put a home resident on any sort of notice that these are law enforcement officers and they have broken into his home, they cannot presume that he is a deadly threat merely because he possesses a gun. And that's what Cooper instructs us, and other cases. The Pena case from 2009 is consistent with that.
I'm still having trouble with this, and it probably won't be resolved in this case. But I'm having trouble with the fact that what if he was a deadly threat when these troopers come running through the door, running up his stairs in ski masks with semi-automatic weapons, and he acted to defend himself. He might have been a deadly threat to them, but did they get some benefit because they're police officers for that kind of conduct?
Question.
I don't know. Are you asking?
You don't need to answer that.
Yeah. I think it's hard to say if everything were the same, but he did in fact point his weapon at them. That is a different case, but we don't have to confront here.
Fair point. He wants to dodge the question. I'd be tempted to answer it, but not answering the question is probably for the best. I'd be tempted to say, like, as your honor was saying, if you were in that position, you'd want to defend yourself. So if he had actually defended himself, I don't think it would change things. So I'd be sorely tempted to give that answer, but his is the more cautious answer and probably the legally better answer. So no need to change things if you don't have to. It's a more conservative answer. So I respect that answer. I'd be tempted to give the less conservative answer, though.
To what extent are you relying today on your alternative argument that give them the first shot, the other 29 were plainly unreasonable?
Well, that is still a claim that we've put forward and that we put before the district court, and we, as we did in brief, we stand by that claim, and that even if the first shot were lawful, the continued shooting were not, and this is a question of just what are the inferences that can be made by a jury. Mr. Betton was shot at 29 times. He was hit 9 times. And he fell backwards and fell into the hallway. I think it's.
You don't know that any of Mr. Betton's shots hit him, do you? You just know that there were 9 that hit him, and he fired 9 of the 29.
That's correct, Your Honor.
He could have missed all. He could have missed with all 9 of his.
That is correct. Although
it might not make any difference. Well, I'm not saying it would. But
yeah. Although
you're not saying that Betton shot him.
I mean, the record, it's unclear whether Mr. Ballew's bullets are the ones that hit Betton or how many times they did.
The name's backwards.
Yeah.
I mess up names a lot. I apologize for that. I messed up yours when I introduced you.
No. But taking the record, the inferences in Mr. Betton's favor are that Mr. Ballew's shots did hit him. And a jury can reasonably infer that Mr. Betton did not stay standing throughout after being hit all 9 times, that he fell at some point. And it's reasonable to infer that he was shot at some point when he was lying on the ground, or shot at, given the fact that there were bullet holes close to the ground where he fell. And so based on those facts.
You mean in the floor?
Near the floor, yes, Your Honor. Like he fell near the floor, and then.
Were there bullet holes in the floor? Is that what you're saying?
They are they're like right near the floor, like on the sort of the floorboard on the wall. You can see them. There's a picture in the record. I can pull the site, but it is from the SLED report has a picture which shows bullet holes, and they have the kind of like tape, marking tape, where you see the bullet holes that are close to the floor on the wall, close to the floor where he had fallen.
Could Mr. Betton recover if the jury were to conclude that Officer Ballew did not fire any shot that hit him?
Good question.
I don't know if he could recover on his excessive force claim if they somehow decided that he fired 9 shots but all of them missed. I think he could still recover against Ballew on the unlawful entry claim, because the officers, including Mr. Ballew's unlawful entry, was a proximate cause of the shooting that occurred. So I think he still could recover on that basis. One other point, and just to emphasize the similarity of this case to Cooper, and defendant in his brief has sort of repeatedly said that this was a
good tactic here at the end. He had basically 2 choices here at the end, because he has nothing left to do. He could either just sit down, which would be one option, or he's going with option number 2 here, which is to go back to his most central point, which is the Cooper analogy, and making sure that's clear. I don't necessarily know that I like one more than the other. Just sitting down is a pretty baller move and has its own weight to it too. But I don't object to this. This is a reasonable move, going back to your most central point, finishing strong. So that's what he's doing. He's got nothing left to do. So go back to your central argument and call it a day.
Split-second action, that this is unlike, and the other case, unlike Cooper, and I think that's a misrepresentation of the record and a misreading of Cooper. The action here took 2 or 3 seconds, which is very similar to what happened in Cooper. In Cooper, the officers were coming up towards the porch door. One of the officers stumbled over concrete, and he looks up, and the door opens, and he reacts and fires. The plaintiff's testimony is he was shot within seconds of emerging from his door. So Cooper is likewise a case that involved, a decision that involved seconds, and this case is no different. So just the short time frame in and of itself does not make their acts constitutional, nor does it entitle them to qualified immunity.
One last piece here. In Cooper, the court said, as in Pennant versus Porter, the court on which the court relied, Cooper's perfectly reasonable rationale for bearing a firearm while investigating a nocturnal disturbance on his own property should have been apparent to the officers at the time of the shooting, and I think weighed into their calculation.
I agree, Your Honor, that was what this court said in 2009 in Pena. That's what this court said in Cooper in 2013, and that should have been, that was the established law as of April 16, 2015, when this shooting occurred. And I think under that clearly established law, Mr. Blue's decision to shoot Mr. Betton and the number of shots that he fired against Mr. Betton constituted excessive force, and the district court's decision to deny qualified immunity should be affirmed in full. Unless there are any further questions. Thank you, Your Honors.
So there you go. No, if there are no further questions, thank you. So he yields the rest of his time. Tactical points out, if you have time left, it's okay to take it. That's of course true, but it's also a good idea. There's a classic rule of selling is once you've made the sale, stop talking, because you can talk yourself out of the sale too. So attorneys know this well, and it's like if you've said everything, it's okay to say I have nothing more to say and I'm done. And you say if there's no further questions, I'll sit down. And it's a very baller move if you can pull it out, because it basically says, well, I said everything I need to say. I've seen it done at the U.S. Supreme Court too. That's baller. I've seen someone sit down after like 12 minutes when they have a half hour. After 12 minutes, be like, if there's no further questions, I'm done. That's a baller move. That takes a lot of courage, and it won in that case. So, if you've said everything there is to say and there's nothing left to be done, yielding your time and sitting down is usually a pretty good move. So there's some trial tactics for you.
Thank you very much, sir. Ms. Sen?
Yes, sir. And may it please the court. So, like you, judges, I'm fresh to this case and having to read all of this material. And one of the things that struck me when I was reading all of this material is that it was this thick, when in reality, what we're talking about here is the actual shooting itself. And what has happened today is what I thought might happen when reading all of this is that we would be led down the path of let's look at failure to train, let's look at lack of supervision, let's look at the entrance and all of those kind of things, when what we're trying to get the court to focus on is whether Ballou was reasonable when he decided to fire the shot. And I understand what the court is saying is that, well, it's all sort of part and parcel. It was the illegal entry, the proximate cause of the ultimate shooting, and that very well could be true. But when we go to trial, we will have the city there. We will have the opportunity, or everybody will, to be discussing whether the failure to train or the failure to supervise
that's not our focus here. Officer.
Yeah, I'm not 100% sure who this woman is. Best guess is that she's a representative from the Attorney General's office of the state or Solicitor General of the state, and she asked for split time. So that's my best guess as to who this woman is. I'm not 100% clear. She's clearly prepped this all ahead of time. What's it tell you? That she's a very good lawyer and does her job well? That's what it tells me.
Ballou said that Mr. Betton had extended the firearm.
What he said, I believe, and let's get the chronology correct, as I understand it, Officer Ballou was the third person in. And I will say that, and because of my knowledge of law enforcement, he would have been committed whether even if he even realized at the time that they had not properly knocked, because at that point he had a job to go in and make sure that the people who had used the ram and were in there first, he had the duty to protect them. But what I saw was that he was third person in. So, and even by Mr.
I'm talking
Betton's,
about what he said in his deposition.
Yes,
Did he say that Mr. Betton had extended the firearm?
he said it was pointed in their direction, and he could not tell whether it was pointed at him or at the other officers.
Right, exactly. And Mr. Benton's testimony is that it was not pointed in their direction. He was holding it down at his hip. So it seems to me that you are trying to ride the facts in the light most favorable to you through this proceeding.
Maybe what the basic misunderstanding here is of simple anatomy, because if I may, Your Honor, when someone's pulling, as he suggested, Mr. Betton, a gun from his waistband and he gets it to his hip, even if it's pointed downward, the hip is in between the belly button and the buttocks. So we're not talking about down at the side. So let's say he pulls it from his waistband, even if it is still in this position, the officers
We don't know that it was like this.
Well,
There's no-
that's in a light most favorable to him.
Well, no, he said he was holding it down. Let me get the language again. He said,
You know, I'm hard pressed that he was using language that precisely. You know, I when this guy was testifying as to what he did and he was holding it down by his side, they're going to look to exact words. I mean, if we're going to get down into anatomy and like what parts of the body are where, I mean, you can't expect them to be that precise. So I hope we're not going to get down to that level. That would just be too much for me.
I had it down. That was his.
Okay, so let's assume it's down at his hip. So that's in the light most favorable
Well, maybe
to
it's
him.
down, fully extended down his side. It
His
seems
arm straight.
like
That's-
you're.
The difference between having it at your hip and having it down at your side is like, I don't know, the difference of like 4 inches. I mean, if you have your full arm fully extended, it's just below your hip. So like, would it be wrong to say I had it at my hip if you had it fully extended? I mean, it's so close that it's like no one is that precise in their language. That's too much for me.
You're arguing. Yeah, I mean,
That is not what he said, and he said
he
it.
said I had it down. I didn't get a chance to pull it up or anything.
He said, and
Well-
there I was seeing stuff moving around my house, and I think to myself, what the F? Reach for my gun, wake up into the hospital. He also says, and he
How
did
about
say,
say 1999 and 2376 to 77?
okay, well, I would have to pull that one, but I'm
Yeah.
certainly looking at the one.
That's what I'm quoting from.
But one thing I will say, having reviewed this like you all did, I never saw anything where he said he had it at his side. And that is what the district judge accepted from the magistrate after no oral argument.
Have you ever seen a case more outrageous on the facts?
I would have to disagree with Your Honor's interpretation of that, because I remember I'm here only for Officer Ballou. Do remember that there were a lot of other officers involved in this.
Okay, so I think one was the officer for the city, and she's the attorney for the officer, and the other was the attorney for the city. So I think that's what's going on. The other was the attorney for the city, and this is the attorney for the officer personally, which makes sense because we're on a motion for qualified immunity, right? So the motion for qualified immunity is denied, which means the officer is going to be sued in his personal capacity. So the officer now has his own lawyer. So the person who spoke first was the lawyer for the city, and now this woman is the lawyer for the officer, and she is a much better lawyer than the lawyer for the city. And that isn't necessarily always true. I've heard many a great government lawyer and many a poor private lawyer. You know, there's this common idea that government appointed lawyers are always bad, or that you're just hosed if you have a public defender. I've seen many a great public defender. I've seen many an incompetent private defender. But in this particular case, she's doing a very good job, again, with bad facts. So she's doing very well.
Particular action. So, like I said, once
Your client
Sir.
told a falsehood too about identifying himself as a policeman. Didn't
Okay, but then again, what you're trying to do is,
he? No, it's not what I'm trying to do. I just asked you a question. Did he?
did he tell a falsehood?
Yeah.
Actually, in his initial statement, he didn't say anything about whether there was a knock or not. But I will tell
But
you,
did
I
he then,
still-
during the investigation, say
at
that?
some point, yes, he did tell Sled that. In addition,
That's a straight out answer to a straight out question.
okay.
Go ahead.
But one of the things y'all mentioned is you didn't see in the video any.
It also makes sense why she's saying that she's new to the case, because he wouldn't have had his own attorney until it was denied. So she's just coming up now on appeal. She wasn't there during all the trial stuff. So the city's attorney had way more time prep. She's just getting this as an appellate attorney. And so she's getting it relatively quick. She's had much less prep time. She's doing a very good job. She's very together. I like this attorney quite a lot.
type of mouths moving. I watched because I'm looking only at Baloo. I didn't know all these other officers didn't sit through their depositions. But when he's got a gun at the man's head that was in the way between them and the door, he certainly was moving their mouth. And
I didn't see anybody saying police. Nobody was announcing themselves. You know, I just don't understand why we're quibbling about the record in the light most favorable to the defendant. The job is to talk about the record in the light most favorable to the plaintiff.
And in the light most favorable to defendant Blue, who is the only one here today, when he comes in, third in, and a gun goes from here to light most favorable to the plaintiff down, then what is he to do except for to protect himself and the lives of his fellow officers?
Good answer.
I'm not saying that what Betton did was unreasonable, because we're going to have to accept the version of the facts there.
You're making a jury argument. This is just a total jury argument.
No, ma'am. What I'm saying is if qualified immunity exists, it would certainly exist if an officer sees a gun coming up, and whether it's at the hip
There's
pointing down.
nothing here that says it was coming up.
That's not the facts.
From the waistband.
That's not the facts. And our precedent is that the court, this court, us, must accept the facts as the district court articulated them when it ruled. And you're twisting around and won't accept the facts as articulated by the district court.
I would suggest that this court wouldn't have job security if you could not look into the record and read what the record was, and all you did.
On a qualified immunity appeal, this is a special kind of appeal. You have a limited right for a police officer to appeal the denial.
There's a question. The question was, what makes an argument a jury argument? What they were saying by saying it's a jury argument is that she is making an argument as to what the facts are or should be. So they're saying that she was making an argument as to you, the jury, should believe X. You, the jury, should find Y. This is how you should rule. So they're saying it's a jury argument because she's saying, well, here's what the facts are. You know, that the gun was here, it might have been raised, it might have been whatever. So when they're saying that it's a jury argument, they're saying, look, this is the kind of argument you would make to a jury, that these are the facts and this is the way you should find. But as the judges point out, in this context, the facts are locked. They are what they are. And so they say, look, it's here, and that's end analysis as far as the facts go. So they're basically saying, look, you're trying to change the facts. Now, personally, on a personal level and on a professional level, I don't object to this on a professional level. She is trying to do, honestly, what I would probably try to do in her position. She's just trying to very subtly and very cleverly shade the facts. So she's taking horrific facts and she is tweaking them ever so slightly, as much as she thinks she can, like just turning up the knob just a little bit on an amp or something, just a little bit to try to make the facts a little bit better. She's just trying to tweak it a little bit in her language to make it just a little bit more favorable. Now, unfortunately for her, the city's lawyer completely blew any opportunity that she would have to do this. If she had gone first, she might have been able to get away with this. Unfortunately for her, the city went first, and the city has completely destroyed any hope she has of pulling this move off, because the judges are not about to take any of this stuff at this point. So like they're like hyper primed to be locked into the record, because the city's attorney was trying to play this game much, much more poorly than she is. And so the court is now like completely like locked down. If she had gone first, she might have gone away with this, but city's attorney kind of screwed her on that one. So I don't blame her for this move, but the city's not, the Court of Appeals is not having any of it at this point. So that's what they mean by saying it was a jury argument.
Qualified immunity, but
Right.
you have to accept the facts as articulated by the lower court and bring them up here. And that's the law. That's the law. Otherwise, you have to wait till the final order.
Okay,
You have to go to trial first. The qualified immunity would get him out of trial.
I would suggest that
And the district court denied it.
qualified immunity would basically not exist if this court were not able to look at the facts
We
to
give
see.
qualified immunity to about everybody. Don't start talking to us about that.
With all due respect, that's not what the
It might
Supreme
not
Court
in
seems
Cooper
to
and not
think.
here, but But Cooper was denied in those circumstances. And they say that Cooper case controls it. And I have some familiarity with the Cooper case. We all do.
Taking the light most favorable to the non-moving party, what happened here was horrendous.
I'll be happy to pass that along, Your Honor.
Okay.
Thank you.
That is a really, really good move from her. I love that answer right at the end where she says, I'll pass that along, because the judge just said, this is really, really horrendous, right? So he just said, your case sucks, okay? So what can she do? She can't admit it, and she can't deny it. She can't say, yes, you're right, because that's end of case. She can't deny it because that's end of case. So all she can do is say, I'll pass that along. And basically, like, it's a judo move. She's passing it. That was brilliant, brilliant move. So I want to listen to that again, because that is just, listen to how the judge phrases this, and listen to this judo move that she does to pass it by. So she can't admit it. She can't deny it. Listen to what she does. It's brilliant.
Non-familiarity with the Cooper case. We all do.
Taking the light most favorable to the non-moving party, what happened here was horrendous.
I'll be happy to pass that along, Your Honor.
Okay.
Thank you.
Thank you.
I mean, guys, that is just a brilliant, brilliant move from her. I mean, I can't even say how brilliant that is from her to do that way. And also another thing I really liked about her presentation is that she was just so even the whole time. She was just so even, and she wasn't flustered. And the judges weren't being as mean to her. I mean, they were being a little bit aggressive in their questions because she has bad facts, but they weren't being nearly as aggressive as they were to the guy attorney. And the reason was because the guy attorney was fighting them so much more, and it was so much more like fighting them in tone. And like, he was fighting them, and he was saying, and they're saying, no, this isn't true. No, this is true. And he was just fighting. And so there's like these loggerheads. The way she did this was brilliant lawyering. She was even. She was not flustered. She had a very sort of consistent, very relatable tone. And when they got hostile with her, she just kept very even, very calm, very professional, very demure, very respectful, very, very sort of passive in a way. And in this kind of environment, this is brilliant. I mean, because look, you can't be beating the table and yelling and stuff with this kind of fact pattern. It's not going to work. So you have to be a lot more. This is just brilliant. And I love her answer right there at the end where the judge says, well, this is horrendous. Basically saying your client sucks and everything he stands for is horrible. How do you answer that? And she just says, well, I'll pass that along. It's like, it's like, how do you be that brilliant to deflect in that moment, having just gotten your teeth kicked in for the last 15 minutes? At the very end, they come up with this bombshell line at the very end, having just had your teeth kicked in for 15 minutes. And like, how do you just respond with, well, I'll pass that along? It's like, oh my God, she's a really good attorney. She has horrible facts, but she's a really solid attorney. So like, yeah. So, you know, I would imagine the Fourth Circuit is going to maintain the denial of qualified immunity. Now, from where I understand posturally on the posture of this, I think they're still going back to trial. So I think this is an interlocutory. So I think if they rule that they go back to trial for some further damages and stuff. So I think this would be sent back down for more proceedings, and then like probably another appeal on whatever judgment would eventually come, because I don't think we're that far along yet. And so this will be sent back down to trial for the actual jury findings, and then like go from there, I think is where we are in terms of posture. I will also point out that the Supreme Court of the United States has given, thank you for someone saying, yeah, it's interlocutory. That makes sense. So the denial of qualified immunity was interlocutory, so they haven't had the trial yet. So they just made this initial findings for the purposes of making that determination. And so they get to still fight about the facts at the trial stage. So they will still have to prove, like all these things to a jury in terms of like where the gun was and all the rest of it, in terms of like the jury making the findings. So these are just like findings for the purposes of this, and they still get to go back to the jury trial and make those findings again. So my prediction is the Fourth Circuit will maintain the decision. They'll go back down to trial. They'll have a jury. They'll have the jury argument over it. I would imagine some of these officers are going to be found liable. The city's going to be found liable because, as they point out, it's pretty horrendous facts. So you'd imagine a reasonable-minded jury is coming back with some kind of verdict in favor of the plaintiff. You go back to appeal on all these issues again and some more, and then perhaps appeal to the U.S. Supreme Court. It would be interesting to see if they grant the qualified immunity if they put in an immediate cert petition. I'm not sure that's possible, but they could try. And it'd be interesting to see if the Supreme Court wants a piece of this, because the Supreme Court has mused in its dicta that it's interested in curtailing and lessening the impact of qualified immunity. There has been suggestion they might do away with it altogether. I think it's a little unlikely. More likely is that they would constrain it much more, because I think there's a lot of people who are very, very concerned about the reach of qualified immunity and the doctrine. And so the Supreme Court has made feelers in its cases basically saying, yeah, we'd like to take another look at this someday. And so maybe this case, regardless of the Fourth Circuit, whether it affirms or denies the qualified immunity, this might be an interesting case for the Supreme Court to take on qualified immunity doctrine, because it's a relatively clean case as far as cases go. I mean, also, how stupid as a police do you have to be to raid a guy's home at night, not in uniform, not with police badges, just wearing whatever, not announcing yourself as police, not like whose genius plan was this? Did I hear correctly? At one point they mentioned DEA, so this was a joint DEA SLED investigation for like a couple grams of pot. Okay, well, I mean, that seems like a bit of an overreaction. So he said curtilage. Yeah, we didn't really discuss what curtilage is, so we'll discuss that a little bit. Curtilage doesn't have a precise legal definition like so many things do, but it's basically the immediate area outside of the home. It's treated basically as equivalent to being inside the home for Fourth Amendment purposes. So when we talk about the home being special, that includes the land immediately outside it. What does it mean by immediately outside? Well, if you're close enough to look through the windows and have your face pressed against the glass, that's close enough. But basically the distinction is between curtilage and open fields. So if like the traditional distinction would be like a house on a farm in the middle of a prairie, old school style. So if like your house is in the middle of nowhere and it's surrounded by huge open fields, not all the fields count as part of the home. All of that counts as part of the immediate home. How close is that? I don't know. Let's say 50 feet. That's a reasonable number, but it's basically close enough to be part of the home as curtilage. So yeah, it's close enough to be like it's inside the four walls, even though it's not. How close that is, who knows? Yeah, well, it's not an issue of trespass. It's just an issue of Fourth Amendment, because it would be trespass on the open fields too. So if you're in the middle of nowhere and you enter a guy's land, as trespass just surely as anywhere else. It's a Fourth Amendment issue. So if the cops trespass, it doesn't have the same Fourth Amendment implications. So, the idea would be that if you have a field full of marijuana in the open for some reason and the cops come upon it, you have a much harder Fourth Amendment case because it's not in the home. So that's the distinction there. If they kept the facts all the same, except the police had killed the plaintiff, could the officers be successfully convicted of murder? They'd have to be tried, which of course we know isn't going to happen, but let's push past that. Can make a perjury claim, damages based on a bad trial result. I mean, you don't need to make a perjury claim. That when these lawyers when the cops get on the stand to say whatever, you get to cross-examine them and you get to use whatever depositions and other stuff they said before. So isn't it true you said this? And isn't it true that you said this other thing? And isn't it true these are contradictory? So basically their credibility is shot before the jury. So if these cops get on the stand, their credibility is zero. So I probably wouldn't put the cops on the stand, but then again, of course, I have no case. So I don't know what I'd do because my case is just completely shot. So fun times had by all. Yes, you can reserve times for rebuttal if you're the first one to go. So the city guy could have reserved time, but yeah, it's probably not a good call in this case. So fun times had by all. She was very well prepped, very well prepared. I don't know what the job security line was meant. I think it was meant as an attempt to humor and meant to attempt to deflect, and I don't blame her. She's having a tough time, so she's got some fortitude. I agree with that. Lawyers should get 50% of the punishment their clients get. I don't think so, Andy. If that was the rule, I'd never represent anyone ever. I've never had a criminal case, but if I ever did, I could take some comfort in knowing that at least one of us is going home. So that's plus. It was a very graceful ending, yes. PB&J to the chat. Thank you for the PB&J, Barry. I appreciate that so much. Thank you, Tactical, for joining us. I really appreciate it. And so good. Can you sue for perjury? Can you sue for perjury? No, I don't think so. Because there's no harm to you from the perjury, unless it was related to something else. So, what would your cause of action be? Now, he can sue for the unlawful entry, which is what he's doing. He can sue for the breach of peace. He can sue for being shot. He can sue for everything else. But can he sue for the perjury? No, I don't think so. There's no private cause of action from that I can see. It's a criminal offense, but the fact it's criminal doesn't mean that it wouldn't also be civil. They're often both. Things can be both civil and criminal. So there's obviously the criminal charge of murder, and there is the civil charge of... what's the civil equivalent of that? I forgot. I forget what the civil equivalent of murder is. But yeah. Yeah. Malicious prosecution. No. You could possibly sue but there's no prosecution going on anymore. This case was never criminally prosecuted for very obvious reasons, so there's not a malicious prosecution charge. Suing for the tort of it would be good. Defamation, possibly, if it's a false statement made about the person. But if the false statement is "I knocked on the door," that's not a false statement about the person. So there's no defamation there. If the false statement is he fired a shot, maybe, because that's defamatory. It's a false statement of fact about the person. So potential defamation, but why bother? There's no reason to bother with a defamation case. You've got a rock solid basic deprivation of civil rights case under 42 U.S.C. 1983. So there's no reason to bother with the defamation. The defamation is nothing. It's not worth the hassle. So is this case clean enough to highlight the issues we're interested in? So it will depend on a whole host of factors, but I would put a non-zero chance of the U.S. Supreme Court taking this someday, because they seem to have an appetite to reevaluate qualified immunity. And even if the First Circuit says there's no qualified immunity here, I could see the Supreme Court taking it to use it as a basis to affirm, to set new precedent. So even if the Fourth Circuit says, yeah, there's no qualified immunity, I could see the Supreme Court taking it to affirm the decision, or at least that's what I hope would happen down the road. But of course, that's a lot of speculation. We'll see what's going on. Joe Tyson, thank you. A bunch of 1Ls with me. Thank you, guys. I really, really appreciate it. The 3Ls probably are done with the bar by now, so they're not panicking as much. And now they're just waiting for results, right? Incidentally, that reminds me, I still have to do 2 hours of CLE. So haven't we seen cases where the thing is they have a warrant so anything goes? I don't know about that, but obviously having a warrant gives you a lot more. Did they have a warrant? It's not clear. I thought they didn't have a warrant, but it was a no-knock warrant for a couple of grams of pot. I mean, Jesus, guys. I mean, just from personal position, first of all, I just want to say I have never actually used marijuana. I know I'm like the only one, but I've never used marijuana. That being said, I think marijuana should be legal. I just don't think it makes any sense for marijuana to not be legal. The collective harms that it's causing are not worth whatever benefits we're gaining. And I think laws generally are sort of a cost benefit analysis. So like What are all the things that are the benefits we're achieving from marijuana being illegal? Well, what are all the costs that we're losing? It's like, I can't balance it out in my head. It just doesn't make sense. I think that from a pure policy position, it's like, it's really hard to justify. I can't justify it in my own head. I think we're a country where people are free. And so the presumption, at least in my mind, is everything should be legal unless there's a reason to make it not legal. And a lot of things, that's pretty easy. We don't need a lot of thought of why should it be illegal to rob banks. That doesn't require a lot of thought, for example. But it's like, why should marijuana be illegal? It's like, well, if it ever made sense, it's like, it doesn't make that much sense now, because I enjoy a good glass of alcohol, and that causes more deaths and more damage and the rest of it. And it's like, if someone wants to use marijuana for whatever purpose, I can't see the justification. The fact that Schedule 1 to me is ludicrous. I skimmed. I didn't read, but I skimmed. At the very end of Obama administration, the DEA wrote like a 400-page memo on why marijuana should be illegal, and it was brilliant. And the reason that I say it's brilliant is because they knew the conclusion they wanted to come to before they started. The conclusion is marijuana should still be illegal. Now, given all the things that we know, how do you justify that position? And it was really, really well done. They worked so hard to make that position work. And if you have the time and you want to kill some time, I'd recommend reading it, just because it's like, how do you make something impossible work? And so I really liked it because it was, to my mind, brilliant lawyering. How do you make some really horrible facts work? And it's just like, I had to applaud it just because it was really well done. But you can tell, you can feel the strain on the page. You can tell that you're reaching. It's really professionally done. It's really good. It's really hiding it, but it's like, man, oh man, you can only hide so much when the facts are that bad. So it's like, Lord, it boiled down to we needed our budget. Well, not quite, but your point is well taken. All right. Anyways, guys, I'm out for now. Thanks again for the super chats. It means so much to me. It encourages me to do more live streams, so we'll do more of these. And as always, you can find me on Discord, Blackleaf, or whatever name I happen to be using. I think at the moment my name is $12 richer. I change it a lot. I'm the guy with the little dragon icon. So you can find me on Discord, on Lawful Masses Leonard's Discord. And feel free to PM me with stories or tag me, and we'll cover stories. We're going to cover that story about the guy who had criticized the judge, who was arrested. He was found not guilty, so we're going to be covering that story this weekend. That should be a lot of fun, and we'll see where we go from there. But I'm going to try to get a little dinner, and then I'm going to go sleep and get up and do my job tomorrow.